Ms. McCarthy?
Your Honor, this is a motion for a Nelson hearing.
Right, and Mr. Stanley, would you like to go forward with that?
Yes, sir, I would, Your Honor.
All right, if you'll swear Mr. Stanley in.
Yes, ma'am.
All right, sir, state your name.
Xavier Javar Stanley.
Mr. Stanley, what are you asking for today?
I'm asking to be appointed different counsel, Your Honor.
Okay, and what are your grounds?
My grounds is, Your Honor, Ms. McCarthy, she's very incompetent. I request to discharge the counsel appointed substitute. Even Ms. McCarthy on this case, Your Honor, it will result in ineffective assistance, Your Honor. She has not provided me adequate counsel whatsoever, Your Honor. I got a lot of grounds. Back in August of 2023, Ms. McCarthy told me that she reviewed the case, determined that I would never should have been charged for this robbery, first and foremost, Your Honor.
Buckle up, guys. Today we're diving straight into a courtroom clash that escalates faster than anyone expects. It all begins when Mr. Stanley steps forward and demands a Nelson hearing, claiming his attorney isn't doing her job. From the very first exchange, tension fills the room as he accuses her of incompetence and insists he needs new representation.
She also met with me November 16th, November 17th, and November 20th of 2023 and told me that I should not enlist the facts in the motion to dismiss. I had the counsel at the jail pull that too as well, to where she told me not to enlist my facts in the motion to dismiss, Your Honor. Let's see. As well as the sworn statements on both cases, Your Honor, we got evidence to where the victims in both situations excluded me. We got one victim lying, giving two contradicting stories, Your Honor. Ms. McCarthy advised me that she would have these charges dismissed due to the police bribing witnesses to implicate me in this situation, Your Honor. That has not been done. She said it doesn't matter the facts because you believe every defendant is guilty until proven innocent. Her words, I got that too right here for you. It's in a letter, if I may approach. The second page is for you. I highlighted it for you. I know all you gotta do is read it.
Provide a copy to the state. Let the state look at it.
I got one for him too, Your Honor, if you need it.
Yeah, you need, if you're going, well, if you're asking to accept that in the evidence, you can just let the.
Just highlight what she said. I wasn't done though, Your Honor. I can continue if I may.
Go ahead, let me see it there.
Judge, with the uniqueness of these claims, Your Honor, that I make, it consists of that letter in the paragraph that you're finna read that's highlighted, Your Honor. And as you can recollect, when I was here December 19th for the motion to dismiss, Your Honor, she said absolutely nothing. She stood where she is now. She ain't defend me whatsoever. She said not one word, Your Honor.
In this segment, the intensity rises as Stanley lays out a detailed list of grievances. He claims his attorney told him not to include key facts in his motion, insists victims gave conflicting statements, and even presents highlighted letters as proof. Every point he makes pushes the courtroom deeper into discomfort as he tries to justify replacing his lawyer.
Me and Mr. Sullivan went back and forth like I was representing her in the courtroom, Your Honor. You know what I mean? More so, Your Honor, if you notice in the letter, on paragraph, she said, I cannot think of a defense that would be successful in trial. I don't need an attorney like that who's incompetent, who does not want to list the facts in her motion, pertinent to the release sought in the motion, Your Honor, does not open her mouth in court proceedings or fight for the defendant whatsoever, Your Honor. She does not, Your Honor. And that's a 4-year-old letter from somebody else. This is what she continues to tell the clients, Your Honor, about you in this courtroom. She continues with the same defense, Your Honor. Ms. McCarthy was supposed to talk to the
record, what I just wrote was somebody from another to another client.
Somebody family mailed that to me, viral mail to the Bay County Jail, Your Honor. This is the same thing that she's
I'm not considering that.
It's cool.
That's what I was going to ask about.
I'm going to strike that from the record, and I'm not considering that, Mr. Stanley. What?
You can throw it away. I don't even.
Just give it back to him. I'm not considering that. I'm not putting it in the file. That's a letter to somebody else.
Your Honor, if I may continue, you were supposed to talk.
I haven't heard anything yet, sir, but go ahead.
I'm telling you, you were supposed to talk to the investigators to interview this bribe witness that they used, the only witness that they used to try to implement me in the robbery. She didn't do that, Your Honor. I got the document with these different victims, Your Honor, where they gave 2 different sworn statements under oath. She has done nothing to present that either to the prosecutor, Your Honor. It's in black and white, Your Honor.
Here, the judge draws a firm line, refusing to consider a letter Stanley tries to enter into evidence. Undeterred, Stanley continues pressing his accusations, arguing that vital investigative steps were never taken. He lists missed opportunities, ignored statements, and unreviewed photos, insisting his attorney has done nothing to help his defense.
These are signed statements. These are sworn statements on the oath. Ms. McCarthy was supposed to get the photos to exclude me as this suspect in this robbery. She didn't do that, Your Honor. I was supposed to go over the victim's statement with her to provide let me see. Ms. McCarthy was supposed to go over the victim's statement, which proved the perpetrator was a Hispanic and not me. She didn't do that, Your Honor. And this is all in my discovery. It's all sworn statements. And I done had this Ms. McCarthy since August, since May. It's been 8 months. And she's done absolutely nothing.
You testified that she had been to the jail to see you, is that correct?
She's been to see November 16th, November 17th, and November 20th. I had the case manager as well as classification pull that video. It's attorney-client.
She went to the jail all those days?
3 days.
I'm gonna let Ms. McCarthy respond at this time. Ms. McCarthy?
Your Honor, the reason that I went all those 3 days is because we were doing a motion to dismiss, and Mr. Stanley wasn't happy with it, and so I kept coming back with it until he decided to sign it.
Because you told me not to put the motion to dismiss the facts.
I'm striking all that. Let her talk. If you need to say anything else, I'll allow you. Don't say anything else while she's talking.
The motion to dismiss was the motion to dismiss. It stated all the facts that would be pertinent to dismissing the case. The reason that I didn't argue when we got to court is because a traverse was filed and there was nothing else to argue about. And that's where we are. We're ready to go to trial.
Mr. Stanley, I haven't heard anything that Ms. McCarthy has done that would that has not been in your best interest or in preparing for your case. If the state filed a traverse, there's nothing to argue about. No, that's it. I've ruled. I'm going to deny your motion. We need to set him for trial.
I believe it's set for trial.
How do you deny it? I'm telling you, she's done absolutely nothing, Your Honor.
Denied it.
Now we see the attorney finally respond. McCarthy gives her explanation, stating she visited multiple times because Stanley kept rejecting her motion drafts. She details why she didn't argue further in court and insists she followed proper procedure. But the judge cuts through the noise quickly, stating he sees nothing showing ineffective assistance and formally denies Stanley's request.
That concludes the hearing.
And I got a video in the county jail to where she said not to put the facts in my motion. I already had them pulled at the jailhouse.
They shouldn't be, they shouldn't be, Ms. McCarthy may need to look into that. If they've got something, they're filming attorney-client.
She perjuring herself in your courtroom, sitting here lying.
That will conclude the hearing, sir. We already set for trial.
I believe we are.
All right, leave it on the trial docket. Don't say another word, sir. Go ahead and take him back in the back before he gets in trouble. Ms. McCarthy. Mr. Nix, you ready? I'm well. All right, Mr. Nix, you're here today on your motion docket. You're representing yourself. Do you still wish to represent yourself?
Yes, sir.
Okay. And I don't know that you have anything pending. I think, have you got the orders dismissing your motion to compel and dismissing your motion to dismiss?
Yes, I just got them.
Okay. All right. Is there anything else today that we need to discuss?
Yes, sir. Your Honor, I got a couple of issues. Your Honor, this is what I don't understand. In the discoveries, the affidavit is not filed. Okay. And in the affidavit that is filed, it's not in the discoveries. There's two different affidavits. I don't know which one to prepare my defense on.
Okay. Mr. Sullivan, you understand what he's talking about? I don't either.
The affidavit that's in the discoveries is not filed. They're not filed. There's nowhere. There's only one affidavit that's filed through the case history. And so the one that's in the discoveries are not filed. It's a totally different affidavit.
I got no idea what you're talking about.
Here, let me show you, Your Honor. Okay, this affidavit right here, this one right here is filed. Here, Your Honor, it's got the numbers up at the top, 22-3101. This is the affidavit that's filed. Okay? In the discoveries, it's a totally different affidavit, totally different statements. It's not a case file copy. It's totally different.
A new defendant steps in, and confusion enters the courtroom instantly. Mr. Nix, representing himself, begins arguing that the affidavit in his discovery doesn't match the affidavit filed in court. The judge and state struggle to understand what he's referring to as he insists that two entirely different documents exist in his case file.
This
Was filed in the court file as a complaint.
sir.
They have a complaint.
Yes, sir. Yes, sir. And then the discovery, the complaint that's in the discovery is totally different. It's not a case file copy. It's not a duplicate. And this was not filed. It's a totally different probable cause.
Mr. Sullivan, got any idea if you want to present that? Show Mr. Sullivan first and then submit it.
So the one that's filed is this one.
The affidavit that's in question, who's the defendant on that?
Sir?
Who's the defendant?
He only has page 2, Your Honor.
I wonder if that's where Ms. Weber is, if that's Ms. Weber's probable cause affidavit.
No, sir, I got hers. It's totally different. I got hers. I got hers as witness. It's totally different.
Yeah, I understand what he's pointing out, Your Honor. I don't know, I guess, what his argument is. I mean, if there's an affidavit that was sworn out but never filed, essentially, what is the effect of that affidavit? It really doesn't matter.
Let me see what he's talking about. And I agree. I mean, if he was arrested on an affidavit, I mean, there may be something to cross-examine someone on.
It's what it appears to me, Judge, is it was a copy paste of the addresses, and then they went back the next day and changed the address to what I would assume is the proper address.
So they changed the whole probable cause. They changed everything on it. They didn't change the address. He changed everything on it.
This section becomes a deep dive into paperwork chaos. The judge reviews the documents and realizes the issue stems from a corrected version filed a day later. Nix, still convinced something improper happened, insists the affidavits should be exact duplicates. The judge explains they were simply updated, but Nix maintains the discrepancy jeopardizes his entire case.
The whole probable cause.
The one that's filed was signed on the 26th, and this one's signed on the 27th.
Yes, sir. They're supposed to be duplicate copies.
Well, they're not duplicates because they were 2 different days.
Yeah.
Yeah.
Again, it's like that they filed it, realized that there was a typographical mistake, and went back and filed a new one.
There's not.
I mean, I don't know what you want me to do. I mean, you've got it. I mean, you've got it in discovery. So, I mean,
Yeah, but it's not filed, Your Honor. I mean, how can you use something
Yeah,
that's
sorry, I
not
didn't know
filed?
it was like before too.
Well,
affidavit of complaint has been filed against you. The
Well,
judge.
yes, sir, but they're not using the one that's filed. They're using the one that's not filed.
But you're not.
Who's ever on the Zoom room, you need to mute your.
You see what I'm saying?
Don't have to go now at 1:30.
It's not filed.
Okay.
What do you want me to? What do you want me to? What do you want to do?
I just need to, I don't know which one we're gonna go by.
Okay.
I don't go by the probable cause affidavit. That's just a way to get you arrested.
Well, that's what you got the probable cause to arrest me for, wasn't it?
I'm not.
You changed it.
What do you want me to do right now?
I want the affidavit that's not filed to be stricken, taken out. Go by the one that's filed.
What? I got no idea what you're talking about, Mr. Nix.
It's not filed. So how can you use something
It's
against me that's
not filed. How can I strike something that's not filed?
Well, how can they use something against me that's not filed?
Do you understand the argument, Mr. Sullivan?
Yes and no. I don't think Mr. Nix understands that the complaint affidavit is not being used against him in the sense that he's claiming it is. The information is what charges him with the crime. The information is what I proceed forward on. The testimony of the officers is the evidence that I will be using to prove that crime. The affidavits are not admissible in trial. They will not be used in trial. They're not going to be used against him.
Sir, he's already used the affidavit against me that's not filed.
I got no idea what you're talking about, Mr. Nix. I got no idea what I can't strike something that's not in there. And even if I could, I mean, there's nothing to strike. I mean, the information just gets you arrested.
Here the confusion escalates as Nix argues a non-filed affidavit was used against him. The judge tries repeatedly to explain that affidavits don't determine guilt and aren't trial evidence. The prosecutor reinforces that charges come from the information, not the affidavit itself. But Nix is fixated, unable to accept that the document he's concerned about isn't legally decisive.
The state doesn't even have to charge you with what the information says. They can amend the charges. They make a charging decision. So you can hand that back to him, but I got no idea. What else do you have today?
So it's about, it's about the sworn statement. Mr. Sutherland said he talked to the officers and there's no sworn statement on the body cam, right? And then you said that there's no technical statement, right?
Correct.
And then you said there was no sworn statement, not even an unsworn statement.
No, that's
Look, this is not stuff that needs to be held in front of the court, Mr. Nixon. That's the problem. You representing yourself. You got to absolutely digging yourself a deeper hole. Now, you have a right to be represented by an attorney. That's what you need to do. I feel confident to represent yourself. But you're having conversations in front of me that you don't need to have in front of the court.
Yes, sir. Well,
Well,
I can't talk to him. I mean,
that's because you're representing yourself.
on the body cam, I need to see the body cams again.
How do we do that when he's pro se? Because if you had an attorney, your attorney would.
I'd have to play it in open court, Judge. I can't provide.
I'm not sitting here in open court and watching. That's not my job. I don't have the time to do that.
Yes, sir. Yes, sir.
That's your problem with representing yourself. You're going to have to figure out some way to get it done.
What I'm saying is, Your Honor,
Listen to me. That's up to you. If you had an attorney, they would take it out there and play it for you. You don't have an attorney.
No, sir, I don't.
That's up to you to
You give me a different attorney besides Roy McCarthy, I'll take a different attorney, but I'm not taking Roy McCarthy.
In this segment, the judge confronts the downside of self-representation. Nix insists he needs the body cam footage played in court, but the judge says he doesn't have time to screen evidence for defendants. Nix argues he can't access it alone, while the judge reminds him that an attorney could easily obtain and review it. But since he refused one, the burden now falls entirely on him.
Did you ask for another attorney?
Yes, sir.
And I've already ruled on that.
I've been asked for another attorney.
So that's the same thing. I mean, if you have to figure out some way to review the body cam, that's up to you. I can't help you with that.
What I'm saying is, if there's no sworn statement, then not.
Listen, do you want Ms. McCarthy to represent you? She can take the video out there and let you see it.
Listen, Your Honor,
Let's go ahead and set it for trial.
With Ms. McCarthy, let me explain something, please, sir.
I think I've already heard that.
No, I don't think you've heard this. I had 5 witnesses subpoenaed for the suppression hearing. 5 witnesses. Okay? She had it with only 2 witnesses.
Okay. All right, let's go ahead and set this for trial. Let's set it for April 1st. 8:30, we'll set it for a trial management February.
I believe he's currently set for the February 5th date, Your Honor.
All right, you ready to get a trial then?
No, sir, I need to see this video. I'm sorry, I need to.
Is it one on the list?
What's that?
Is it on your list?
He's one that, depending on some ailments, he may make it. He's kind of on the fence. So I'm fine leaving him on if you want. I'm fine moving him to April, either way.
Let's move it to April 1st at 8:30, and you just figure out some way, the body cam. I can't help you with that. I'm not sitting here watching.
Okay, but while I'm here, I need the CHAD logs from July the 20th.
You're gonna have to file a request.
Okay.
April 1st at 8:30, March 15th for trial management.
Your Honor, I was appointed on to represent Mr. Palmer on his motion to withdraw plea. I had the chance to speak with him by phone yesterday, and we corresponded prior to that by letter.
The back and forth intensifies as Nix argues about trial readiness, missing witnesses, and unresolved evidence. The judge sets the trial date and tries to move the case forward, but Nix keeps circling back to his complaints. He insists he can't proceed without reviewing the video, yet rejects the attorney who could help him, leaving the judge visibly out of patience.
The burden in this case is on the defense. My question is how the court would like to proceed, whether I can proffer what I anticipate the argument is, or whether you would like to hear testimony from Mr. Palmer himself.
It didn't. I don't matter either way to me, Mr. Sullivan.
Doesn't matter to me, Your Honor.
If you want to go ahead and proffer, that's fine.
Your Honor, based on Mr. Palmore's motion to withdraw plea, there are two significant issues that I believe are to be raised. One is during the plea colloquy, you went through the traditional plea colloquy that you do hundreds, if not thousands of times each year. But when you asked Mr. Palmore if you thought this plea was in his best interest, his response was hell no. You followed that up with a question as to whether he wanted you to accept the plea, which you did answer in the affirmative. I think that, however, the court did not go far enough in determining the voluntariness of his admission to the no contest plea to the charges based on that statement. I don't believe the one additional question was sufficient to cure any defect in finding that he understood the terms of his plea, whether it was in his best interest, and particularly the voluntariness of it. He had stated in his motion to withdraw that he was under pressure and was given approximately an hour to determine whether he would accept that plea. He was given some advice from Ms. Bennett that if he didn't take it, went to trial and lost, he would serve 40 years to life. So the sufficiency of the colloquy, I would say, is in question. The second major issue in terms of allowing him to withdraw his plea is that he was given the opportunity to speak with Ms. Bennett in the attorney-client rooms off in the courtroom. During that, Mr. Palmore requested an opportunity to know what his family wanted him to do. Ms. Bennett purportedly called his family, spoke either to his sister or his fiancee, Miss McDaniel, and then conveyed to Mr. Palmore that they said if it's up to the judge, you need to take the deal. After he was sentenced and taken back to the jail, he was able to get a corrections officer to let him place a phone call to family members trying to be placed in segregation in anticipation of his transfer to the Department of Corrections, at which time he talked to his sister, Miss Whitney Dean, and she conveyed to him that she couldn't believe he took the deal, that he should have gone to trial, and that it wasn't that wasn't what he had they had told Miss Bennett to convey to him. Based on those two issues, and there are other issues that are on appeal, but based on those issues which are pertinent to the motion to withdraw a plea, I believe it'd be a manifest injustice if Mr. Palmore was not allowed to withdraw his plea at this time and proceed forward to trial on the underlying charge, to complete discovery that he alleges was not done in the 3 years the case was pending with his prior counsels, Mr. Middleton and Miss Bennett. And he understands that the cases that were consolidated could be revived if you allow him to withdraw his plea. We had hoped his sister would be here, but I've called her name numerous times and have not gotten a response.
Mr. Sullivan?
Your Honor, as far as what Mr. Palmore's family wanted him to do, I don't believe that that's relevant. It's ultimately the defendant's choice to go to trial, take a plea. The simple fact is that Mr. Palmore was picking a jury that morning. He was colloquied, as Mr. Meredith said. I believe that colloquy was sufficient. The choice that Mr. Palmore was faced with was the choice between going forward with picking a jury trial and facing an enhanced sentence as a habitual offender, which would have exposed him to a life in prison sentence, or taking the plea deal without the enhancement, which he ultimately chose, which was for 25 years. Faced with that option, he chose the lesser penalty of 25 years. There's been no showing that there's any valid reason to allow him to now go back and withdraw that plea.
I'm going to take it under, I'm sorry, Mr. Mayor.
Your Honor, the issue of whether he qualified as a habitual offender, that is another thing that the record is not clear when or if Ms. Bennett conveyed that to him about the habitual offender. I think that was brought up the morning of trial.
It was discussed prior to the morning of trial. I had held off filing the motion because Ms. Bennett had asked me to wait so she could continue to talk to her client about the plea deal. So I had held off filing the notice. I came to court the morning of trial with the notice in hand, and my understanding is that she took a copy of that back to the attorney visit room to go over that and show Mr. Palmore that I had it, I was ready to file it, and that if we were moving forward, I would be filing it.
And I would direct the court's attention to paragraph 5 of Mr. Palmore's pro se motion about the habitual offender situation. So if you would review that.
I'll take under advisement. Just one thing for the record, you indicated that Mr. Palmore only had 1 hour to decide the plea. It's my understanding, I may be wrong, and Mr. Sullivan, you can correct me. I know, Mr. Meredith, you weren't involved, but I was contacted on Friday afternoon to have a hearing Friday afternoon to allow Mr. Palmore to accept the plea. And I declined to open the courtroom back up for him to do that. Said, and based on my message to Mr. Sullivan and Ms. Bennett, and I actually to Mr. Palmore through Ms. Bennett, was to wait till Monday morning and to see if he still wanted to take the plea. But it was my understanding that he wanted to take the plea on Friday, and I declined the opportunity to do that.
That is correct, Your Honor.
All right. Anything else?
Paragraph 1 of his motion talks about his being misled by Ms. Bennett in terms of if the motion to suppress was not successful, he'd be taken to trial. So it wasn't until after that motion that there was any discussion or urgency by his counsel for him to accept any plea. Now, whether that happened Friday or Monday in the courtroom, I don't know.
Well, I think we had trial management on Friday, and
So,
then after
when my motion going to advisement, when I'm going to know when you going to deny it, like when I'm going to know what's going on.
whenever you get an order from me is when you'll find out. All right,
Okay,
that'll conclude
well,
today's hearing. Good luck to you, Mr.
How
Powell.
long is it going to take for you to
I got no idea. I just told you whenever I get to it. That'll conclude the hearing, sir. It won't take too long.
I conclude the hearing when I got to say something. Like,
What do you want to say? Go ahead and say it.
I'm trying to figure out, like, when will my motion be ruled on? Like,
It will be ruled on fairly quickly, sir. I'd say sometime within the next 10 days.
okay. All right.
That'll
thank you.
conclude today's hearing. Yes, sir. Good luck. You're doing well. And Mr. Beecham, you're representing yourself. I think I've already found that you're competent. You understand at any point in time you can ask an attorney to be appointed to represent you.
Yes, sir.
Do you wish to continue to represent yourself?
Yes, sir.
Okay.
Well, for I have a set preliminary hearing today. Sorry.
No.
That was the last motion. For adversary preliminary hearing. You set it off to today.
I don't see a motion for an adversarial hearing, sir.
Judge, and it's been denied. If you go back to December 4th, there was
You denied
a
it with
motion
another motion?
for preliminary hearing. However, that's what it was styled.
Okay.
If you actually look at it, that's not.
Oh, in support of the declaratory
I
judgment?
orally made one in court on the last hearing, and you put me off to this date. I orally made one up under the rule. It was within the 30-day mark. I had been incarcerated 30 days without an adversary preliminary hearing. I motioned for one, cited the rule. I wasn't charged within 21 days of the charging document, so if anything, at least could I be released on my own recognizance, according to how the rule says. That was the day I thought we was having a hearing. I can cross-examine the witness and determine probable cause.
So,
Judge, there hasn't been a motion filed.
I was an oral one made in court. I made it. I've been incarcerated for 30 days. It took you the time for filing within 21 days. You didn't meet it. And so I thought today I was going to have a probable cause determination for that hearing. I'm entitled to it by the rules.
I don't see that. And I don't recall a oral motion to do that. There was a 40-day rule, which we call a 40-day rule.
No, it wasn't about the 40-day rules. It was a adversary preliminary
you want to
hearing.
file, I think you can file that motion anytime. If you want to file a written motion, we can set it
For the adversary preliminary hearings, Your Honor, I had already made one in court. I thought that's what I was going to be.
I don't
here for
recall
today.
that, and I'm not having a hearing today, but if you want, I don't think you waive your right. And I think you can file, unless I'm incorrect, I think you can file if you want to file a written.
It's actually within the 30-day.
I'm not having a hearing today. I'll give you an opportunity if you want to file
Okay,
a written.
thank you, Your Honor, but can I be released on my own recognizance
Motion
according to
denied.
what the rules say?
Motion denied. But if you want to file a motion for preliminary hearing, I'll have that February 22nd. I don't believe there's a time period,
Adversary
is there?
preliminary hearing, it was for 30 days, but if you're willing to take one in for the next, I'll file the
You
motion.
just file your motion for preliminary hearing, okay? And file, and remember, you give the state, I'm assuming you're giving the state copies of all this you're filing.
Yes, sir.
Okay. All right, anything else today?
You want me to put it in writing? You said that's
Yeah.
it?
Yes, sir.
And what date was that?
February 23rd at 9 o'clock.
And that'll be the adversary preliminary
Yes,
hearing
sir.
for the
You
record.
file the motion.
Yes, sir. Thanks.
The courtroom shifts to a different defendant, Mr. Palmore, and the tone becomes deeply legal. His attorney attempts to withdraw a plea, arguing the defendant didn't fully understand his options, felt pressured, and was misinformed about sentencing risks. The state counters by saying Palmore knowingly chose the lesser penalty. The judge listens, questions timing issues, and ultimately takes the matter under advisement before closing the hearing. All right, guys, if you enjoyed this breakdown, make sure to like the video and subscribe to the channel, and we'll see you in the next video.